In the case of SMART versus the National Telecommunications Commission, administrative agencies possess quasi-legislative or what we call as rule-making powers and quasi-judicial or administrative adjudicatory powers. So both sila, parang they have some power of Congress and some power of the judiciary. So the rules and regulations that administrative agencies promulgate, which are the product of delegated legislative power to create new and additional legal provisions that have the effect of law, should observe the following. No? So again, since administrative agencies are sometimes or oftentimes granted quasi-legislative powers, meaning the rule-making powers, the rules that they create should observe the following. Number one, it should be within the scope of the statutory authority granted by the legislature to the administrative agency. Secondly, the rule must be germane to the objects and purposes of the law and not in contradiction to but in conformity with the standards prescribed by law. And finally, it must conform to and be consistent with the provisions of the enabling statute in order for such rule or regulation to be valid. So, ano naman,